Hi everyone, welcome back to World Class Inventors. This is video number 27 in the series. This is going to be the third and final video in the triad for patent pending, constructive notice, and there's a topic I wanted to throw in the last two videos and I didn't, and it has to do with a letter that you would write to a would-be infringer. It's called a cease and desist letter. So let's lay the groundwork. You've filed a provisional patent application. It's in the office. You've had this idea in your head for a long time. So you got excited and you started building this product. And let's just say you're selling it right now on the internet, at flea markets. I'm assuming you already have your own website for this scenario. And you're going to be following up this provisional patent application, most definitely because you're selling product. So you're going to be doing a non-provisional. And let's just say you're going to have 10 claims, which is pretty healthy. And you're going to do a proper specification, a detailed specification. Detailed enough so that when the examiner, he or she, is reviewing your application based upon the prior art that they've pulled up, they're going to get an education as to what your product actually is and what it does. Now, those professional drawings only bolster your position. It gives them a pictorial to see what your invention is about. But your description makes it come alive for them. They can actually begin to visualize it somewhat. And then they're going to go and do a deep dive on your claims. And they're going to make sure that your claims lives up to your specification and your drawings. They're going to tie them all in. And then, of course, they're going to examine them based upon the prior art that they've pulled out for other patents that have been granted in the past. And it doesn't matter whether the patents have expired or whether they're still active, meaning in the case of a utility patent, 20-year lifespan, and then you count backward. And I believe with the design, it's 17 years, but don't hold me to that. I'm not an expert on design patents, but I know it's less than the 20. Most of you are going to be filing utility patents anyway, and you won't be filing per se design patents or plant patents, and that's based upon the plants that populate the earth, basically plants that we eat. Okay. So, I have to establish something else. That you're really not legally trained, that you haven't got into any legal confrontations, that you're pretty much a neophyte when it comes to dealing with legal matters and attorneys. So let's just go there. So, you're at the flea market, you're selling your product. It's going swimmingly good. You're almost ready to file your non-provisional. And you're in Walmart one night, just like I was. And that's a whole nother story, and we'll get into that later. It's in my books. And you notice that there's a product on the shelf that Walmart's carrying that is very suspect. I mean, it is so close to your idea, so close to your invention and your claims, your heart sinks to your feet. Well, you're upset. And all the voices out there, and I mean the PTO, because right on their website, they give you suggestions what you can do. Lawyers that you could have interviewed, intellectual property attorneys that you could have interviewed, maybe even invention help services companies, which I kind of advise you to steer clear of. You can do this on your own and do a much better and thorough job than getting them involved. The voices out there have told you you're protected under patent pending. And I'm telling you, You're not. All as you have is a filing date and some point in time in which you can establish your constructive notice, meaning when the other side should have been aware of that you have a patent that has either been put in the office under an application form or whether you've been granted a patent. Of course, your constructive notice has way more teeth in it if you've been granted a patent with claims. So let's fast forward just a little bit. You have an attorney picked out, so you've spoken to he or she a little bit about an upcoming non-provisional that they're going to help you file. And now you're going to say to them what you've just experienced. You're going to recount what you've just experienced. And you ask them about writing you a cease and desist letter. And that's fine. They'll be happy to do it. They're clocking in at $300 to $400 to $500 an hour, whatever the case is. They'll stand on their head for you. So they're going to write you a letter. Now, again, I have to assume that you're never been involved in a lawsuit, you're not litigious, you've never been embroiled, and you're basically tabula rasa when it comes to this sort of thing. That means blank slate. It's all going to be new for you. And that's the beauty of this series. I'm going to teach you what's over the crest of the next hill and what's around the next corner. Now, I sold real estate for 22 years, residential real estate, and I've dealt with hundreds of attorneys. I went searching for attorneys to represent me for a good year and a half, 2 years, and I've dealt with intellectual property attorneys, litigators. So I pretty much understand how that animal works and how that system works. And personalities of attorneys run the gambit, from passive to logical to excitable to hot to bombastic. They cover the spectrum of human personality. Most attorneys enjoy a fight and most attorneys love to joust. So when you're talking to this attorney about writing you a cease and desist letter, have it be cordial and have it be firm. No sense in coming out with guns blazing because you really don't have much of a leg to stand on. You haven't even filed a non-provisional application. And I'm going to teach you all about that, and I'm going to be going over the same ground somewhat once we get into the non-provisional patent applications. But for right now, I just want to school you on where you stand with the provisional and patent pending. So have a cordial letter written with authority. You're going to send it to the other side. They may or may not respond to you. What I'm trying to get across to you in this teaching series, we're playing a chess game. It's highly sophisticated. We're going to be tiptoeing around landmines, and you are coming virtually at every opportunity from a position of weakness, not a position of strength. Now, why is that? Well, you're a sole inventor. You're a backyard inventor. You're probably undercapitalized. I know when I filed my first patent, I had about $2,500 in the bank, and I ended up bartering with my attorney. He lived close by, and I ended up doing some work for him in his house. So money doesn't grow on trees, and this can be a very expensive proposition at times, and your costs can escalate out of sight rather quickly. We want to keep it down. We want to keep level heads. So anyway, this other side may or may not respond to you. Hopefully they do. The first thing they're going to say is, okay, where are you intellectually? What have you done? Do you have a patent that's been granted to you? We'll research it. We'll give it to our outside counsel, and they'll evaluate it for us for your strengths and your weaknesses, and they're going to do a claim construction on your claims. Well, you're going to come back and say, well, gee, I have a provisional filed. It's in the office. So I have a date certain. I have a priority date, and I plan on filing a non-provisional. And at the moment, I'm going to have substantial claims. They're going to come back and say, well, you haven't filed it. All you have is a priority date and a provisional patent, which doesn't get read or even machine read. And you have a priority date. We don't know if you're going to follow it up with a non-provisional. We don't know if you're going to get your non-provisional granted. We don't know if your claims are going to be accepted in the form in which you're submitting them. We don't know anything. Right now, it's pie in the sky on your side, and it's hearsay. So at this notice of your constructive notice and your cease and desist letter, we're going to be very polite to you. We're working on our own patent application. We're going to be filing our own non-provisional patent. And we'll just wait and see who gets their patent first. So at this juncture, we appreciate the letter. We know that you've put us on notice. They're never going to say that, so strike that from the record. We're going to continue to manufacture and market this product until further notice. And we'll see where all this leads us in the next 2 to 3 to 4 to 5 years down the road, because we don't know how long it's going to take for the PTO to examine, to rebut our patent applications, and to award us our respective claims. So for right now, thanks but no thanks. We're just going to go on. And then the conversation ends. You see, you were just a paper tiger. And the voices out there told you to pursue them. And I am definitely telling you that the PTO has it on their site. Lawyers write opinion pieces all the time about shouting about your idea from the rooftops by sticking patent pending and your registered number on there. It's all really a bunch of nonsense. So the bottom line is, hold yourself back. Try not to build a product and get it out there until you've been protected with a set of claims that the government has approved in the form of a non-provisional patent application and a subsequent grant. As I've mentioned before in this series, and I'm going to begin to mention it again, we're dealing with patents, and we're dealing with patents only at the moment. There are other ways in which to protect yourself, and they are trade secrets, documentation, inventors' notebooks, trademarks, trade dress, service marks, and the like. And it's this Chinese menu of protection mechanisms that's going to end up protecting you at some point. In my humble opinion, as backyard inventors, we shouldn't just be depending upon our patents. Patents are only one form of protection. They're complicated. They take the most amount of time to get awarded. It's the most expensive to apply for. It definitely takes more time to get a patent awarded to you than a healthy trademark. And a trademark is a gorgeous way to protect yourself. And so are trade secrets should they come. So don't put all your stock in the fact that you have a patent. Patents have strengths, they have weaknesses, they can be argued over. And I'm going to leave you with one last thing, and we're going to revisit it in future videos when we get into the non-provisionals. But if you've listened to the end of this, you'll know one thing. Patents are like stop signs. If the big truck wants to run it, it's going to run it. And then the fight begins. And I didn't make that up. A good intellectual property attorney told me that a long time ago when I got into a very highly complex intellectual property scenario with Honeywell International. So there's much to come. I'm going to put these 3 videos in a playlist and you'll be able to listen to all of them. Again, thanks again for your time. Thanks for watching. I hope I'm teaching you something. God bless you, and I'll see you in the next video.